Tallahassee Ethics Board. We have an agenda somewhere. First item on the agenda is the approval of the minutes from our May meeting. Does anyone have any comments, corrections, or additions? Seeing none, Ms. Graham moves that we adopt the amendments. Mr. Payne seconds. All in favor say aye.
Aye.
Opposed, nay. The amendments are adopted. The next item is the series of items in the Ethics Officer Report. The first one is the monthly activities since the last meeting. Ms. Meadows-Keefe.
Thank you, Mr. Chair. May was another month that included a fair amount of ethics education. We had a special group of, am I getting feedback?
No.
Okay, I just hear feedback. We have a group called the Future Leaders Academy, which is young people that come to the city for the summer to learn and to get employment skills. So I'm providing ethics education to anyone that participates in city activities. So it was my privilege to educate them. There are also, for the first time, I'm training part-time Parks and Rec employees. It looks like the city has given to me the ethics education responsibilities. So I'm doing that citywide for many groups. I was happy to have Mr. Payne attend my monthly ethics education that I do for employees. He actually came and endured almost 2 hours of ethics ed. And I would encourage you all, I do it once a month, different locations, either here or a satellite location. You're welcome to come and check out the education that I provide. Trying to think if there's anything else outstanding. We are continuing also to work on the budget for next year.
Okay. Before we go to the next item, I should have mentioned Ms. McNeil is excused. Mr. Smith is running late. We expect to see him shortly. And Ms. Graywall, do I need to recognize you for an announcement?
Yes, I am officially resigning from the board. I actually accepted a new position that just developed very quickly in Fort Myers. So this will be my last meeting. I have an official resignation letter as well. I don't know if anyone needs that, but I just wanted to thank you everyone for your time here. I very much enjoyed my time, and I wish it had been a little bit longer, but life has ways of, changing everything very quickly.
Ms. Graham.
Well, I would personally want to say how much I've enjoyed getting to know you, and hope the opportunities in Fort Myers are wonderful for you. And I believe you were appointed by the public defender. Mm-hmm. Is that accurate? Yes. So does our public defender know that we're going to need to have a new member appointed?
Yes, ma'am.
Okay.
I've already communicated with him, and
okay.
He's already like, gosh, you just appointed me as an appointing authority, and I'm now on my third appointment. So, yeah, he'll have a name forthcoming. Hopefully that person will be present in July.
Okay.
Yeah, I too am sorry we're going to lose you. I wish you well. Yeah. And I would note that the public defender, I think, could, if nothing else, could go back to our list of applicants from the last time. And there were a number of people there who would have been or would be great board appointees. So I'm hoping we're not placing a big burden on the public defender.
That list of applicants and their resumes has been sent to the public defender already. So he's taken a look at those.
Right.
But all the best to you.
Thank you very much. Thank you.
Ms. Meadows-Keefe, on item 3B, monthly report of issues received. Let's do 166.
Okay, number 166. It may have been something even that I referenced last month. This person actually enjoyed the conversation so much that he called back a second time to again discuss issues related to his community development district. But I re-explained to him what my role is. I listened politely, commended him for civic engagement and for enduring CDD meetings. And he just thanked me for my time. So there was no need for further action on that matter.
Any comments, questions? I think something we might put on a future agenda is all of the different bodies that are not the city, but where the city has kind of a controlling interest, and what our jurisdiction, if any, is over those groups. But that would be an interesting discussion for us as a board to have. So we can think about that for the future.
And it would also be helpful, I think, to the community to understand that.
Item 167.
167. This person called to discuss, and I think we've heard this several times from the same individual, with concern about a healthcare provider entity in the city of Tallahassee. And I reiterated to this individual the capacity of the board to handle that. I think later on, I don't know if it's in this report or elsewhere, that the individual continues to have issues with the lease agreement between the city and this healthcare entity, and I believe I provided those agreements to the board members for their review.
Yeah, that's coming up as item F, so we'll get to that.
Got it.
So anybody have any comments or questions on item 167? Appears there is not an ethics, something within the jurisdiction on ethics on this. Okay, item 168.
Number 168 is an individual, again, who has come here before, related to cancellation of meetings and accessibility to meet with city staff. And again, sort of re-advise that individual about the board role, and felt as if this was an issue the board should close.
Any board member see anything here on which the board could take action? Good. All right, seeing none, without objection, then we would go ahead and close that. That would move us to item C, which is the monthly budget report. I would point out to you that things on this are in line with where we have been in the past, with the exception of legal services. That in part is because this is 4 months worth of billing due to our issues with contracts and such, and also the fact that we've had a good bit of work on the recommendations to the City Commission, on rewriting our bylaws, on writing policies and procedures. So we're in an unusual period of expenditure that I would think after this month would go back pretty much to normal. So that's a bigger number, but again represents 4 months. Is there anything else on this, Ms. Meadows-Keefe, that is out of line with our normal monthlies?
I would not think so, Mr. Chair.
Okay.
Mr. Chair, I'm sorry. I apologize. If I could be recognized
Please.
again. I think this was on my report, but I have reached out to the mayor and all commissioners to discuss our budget with them. This is their first go-around for most of them with budgeting for the ethics office, and so I was able to meet with 2 commissioners related to our budget this last month.
Okay, any questions, Ms. Meadows-Keefe? Next is remember, there are D and E are, D is all of the public records requests received by the city during the last month, and E is the subset of those that looks to be of particular citywide significance. They're not asking for, information related to a particular piece of property or a particular utility bill. So if we handle these together, is there anything on here that any member sees as something that we ought to follow up? I would note from last month, we heard about a comment about public meetings and out-of-town meetings and how that all works. And you will see when we get to it, to item 10, which is items for next month, basically. I'm going to suggest that we include that this would relate to 219-264, that we, as a board, look at what the law is, what the Attorney General and case law opinions are on out-of-town meetings by entities like a city commission, and how you guarantee that the public has access and can provide testimony related to those meetings, and what the requirements are concerning any decisions that might be made at those out-of-town meetings. But that's one that I think probably is worth this board following up, because it's pretty clearly in the ethics area. But does anyone have anything else on any of these? Okay, seeing none, that moves us to the Tmh lease. I would point out, a couple of years ago, the board did review the Tmh lease. And determined that we could not find anything within our jurisdiction. What we were urged at the last meeting to do was use our moral suasion to weigh in on the issue, even though it's not ethics. A few things from these lease documents, which are fairly voluminous. In 2015, the lease was extended. It was set to expire September 30th, 2022. It was extended a couple years ago to September 2056. One of the reasons for those long periods is because there are bonds involved for renovations and such, and so you've got to have a period that will meet or exceed the period of bonds you may issue. The documents point out that the hospital has deeded some land to the city and leased it back as part of the lease agreement, that in addition to the $1 a year lease amount, the hospital also has to pay debt service, utilities, taxes, any special assessments, has to maintain the facility and replace equipment as necessary, and the replacement equipment becomes the property of the city. So it's a little more than $1 a year. The hospital is required to maintain $1 million liability insurance and to fully indemnify the city. So those of you who've worked in healthcare know that that is a relatively meaningful clause. And the hospital's agreed to operate a not-for-profit medical center, full-service hospital, without discrimination, without denying emergency care on the basis of inability to pay, but has retained the right to refuse to admit patients because of a lack of facilities or to protect the welfare of patients already admitted. Those were kind of highlights from this. So I think it's probably not an atypical healthcare agreement. I think based on the testimony and other things that we have heard and seen, there probably are big public policy issues here, as there are in most issues dealing with healthcare. But I guess my question to the board members is, does anybody see anything here that's an ethics issue? And
No, Mr. Chair.
I'm seeing heads going back and forth just the same way that mine did after going through all this.
No, Mr. Chair, it's an important issue, but it's not an issue that falls within the jurisdiction of this board.
Right. And I think there are probably a lot of issues like that. They belong to somebody, but not us. And in this case, probably somebody who's elected to office. Okay, does anybody have anything else they want to do for the board to do on this issue?
Mr. Chair?
Ms. Medowski.
If there are more phone calls on this issue.
I think you can say that we have closed the issue.
Okay.
Item 4, Ms. Graham.
Yes. For numerous reasons, I believe that this item should be moved to the agenda of next month's meeting.
Okay.
And I can elaborate on the reasons, but I don't think it's necessary. The substance that we're dealing with today and other issues, I think, takes precedence. And I think next meeting, the issue will be more ripe.
Okay. Any objection to pushing this to next month? We do have a pretty full agenda tonight, and the second of the two big things we got to get done after our recommendations to the City Commission would be our bylaws and procedures. So that will go to July. On the revision of bylaws, I'm sort of planning on Mr. Smith taking the chair here, but we'll get as far as we can. I have given you a 2-page document that goes line by line. You saw a proposed revision of bylaws last month.
Yes.
I can tell you on this and the policies and procedures that Mr. Claypool and Mr. Reed and Ms. Meadows-Keefe and I spent 6 hours in a room last week, as well as before that and since then, numerous telephone conversations and emails back and forth trying to get all of this right and make sure that we've got it as accurate as possible and, to be real honest, in my view, as pro-board as possible, leaving the board and the individual board members with the maximum amount of discretion that we can have and still be operating in the sunshine. So what I'd like to do is just walk through these individual items and see if anyone has any comments or if anyone needs to make any changes. The first one is on lines 14 to 18. We lengthened, but I think improved the mission statement of the board. So I'd give you a minute to take a look at that.
Do we need to make a motion on each of these, or are we going to take them in
What
mass,
I
or-
would like to do is we were very formal in amending our recommendations to the City Commission because we had one bite at that apple, and when we were done, we were done. This remains in our jurisdiction at every meeting, and we can make changes. What I'd like to do is go through all of them as a package, get general agreement, and then take one motion at the end
Okay, I
to
agree.
incorporate all of it and make it much less formal because this is
Yep.
solely on our side of the court.
I agree.
And we can go faster. So we originally tried to write a very short mission statement. This was about 4.5 years ago. This fits kind of along with what we have in the charter and adds that, particularly that phrase at the end, serving as the guardian of the public trust. That's a little broader maybe than our charge, but it goes to the fact that some of the issues we're reaching out and finding issues that we think are do influence the ethics environment, like when we wrote the letter to the City Commission about free parking passes at the airport and how that could be perceived as a gift and get you into all of that kind of ethics thing. So we as a group thought this was a fair revision of our mission statement. But we are certainly, this is just our recommendation to the board. So people good? All right. There was a document that was briefly noticed that there was a slightly earlier version of the document we're looking at. You'll notice on the two-page handout I gave you, in parentheses at the end of most of the items, it will refer to the line number of that document and tell you if there were any words that were different. Hopefully nobody has that old document, so I'm not going to talk about the parenthetical points at all. On line 163 and 64, it says specifically, board members are not the records custodian for public records requests. The law allows government entities to say to whom you make your public records requests, because there were people around the state who would go to, for instance, a groundskeeper at a county and make a public records request and then sue when the record didn't show up. Well, the groundskeeper didn't know enough. So we're trying to protect the board members and recognize that we're all volunteers. This is why we tell everybody, if you get an email from anybody, send it in to retain or send it into ethics@talgov.com. That all gets retained in the city's system, and you can do one search and get it all. You don't have to come to each of us individually. So this is there to protect us. Questions? Line 201 allows the election of the chair and the vice chair at any time. The bylaws require that we re-elect the chair and vice chair annually. I am here to say that the day that you are unhappy with me and want to vote for somebody else, I will vote with you for that other person.
Mr. Chair, we love you.
Always the politician. The Honorable Miss Graham compliments me.
I'm smart like that.
On line 209 through 227, there is new language about the ethics officer and the responsibility, the charter does say that the ethics officer shall be an employee of the city, a full-time or part-time employee of the city, or an independent contractor. So we pick that language up here, and then we go on to say if the ethics officer is an employee, if that's what the board decides, that we will write their job description, do their evaluation, we will hire, discipline, and terminate, and we will set the salary. But everything else is going to be done pursuant to the city. So all city policies, benefits, leave, all that stuff, because we don't have a human resources office as a board. So all that stuff, we're just going to piggyback the city. We're going to control the things that are big and important. That had not been here before. I think we had all assumed that, but this says it affirmatively. I would note that we need to add on line 212, I would suggest we add, if you go back to line 168, our existing bylaws say board members should not use their position in any manner that diminishes public trust or gives the appearance of impropriety. I think we should add that same sentence for the ethics officer. And we would do it on line 212 to say, so this is not in your draft, and I would move, this would be a motion, I would move that we add this. The ethics officer shall not use the position in any manner that diminishes public trust or gives the appearance of impropriety. So Ms. Graham's going to second. All in favor say aye. Aye. Opposed, nay. And so we have added that. Then going to line 294, this says that the ethics officer ensures that initial investigations of complaints are conducted, but does not necessarily conduct them. Our thinking was that we get a complex complaint or a complaint that involved the board or a board member, that we ought not to have the ethics officer do that. Even the preliminary investigation, we ought to have somebody, another third impartial person. Like if there's a complaint filed against me, Ms. Meadows-Keefe ought not to be doing the initial investigation of that because I'm one of the board members for whom she works. There ought to be somebody who can be honest about Richard's activities, or doesn't have to worry about being honest about my activities. Let me put it that way. So any objection to that one? On line 298, this, Ms. Graham, was for you. It says the ethics officer would maintain board social media accounts as directed. We've talked about this. This is one of the things we know we need to follow up on. I think we probably are headed toward maybe a Twitter account where we can get stuff out. But that clearly puts, says the board should decide this stuff, and the ethics officer will do it. Mr. Payne.
Is this assuming an IT function of the ethics officer?
Not necessarily. It would be maintained. So I think when we decide to do that, we would have a discussion, and this will be in a future meeting, that about how we want to do it. If we want to hire a consultant and how we would work with it to make it look like it's sort of branded, sort of like the city, so people understand, that we're not the county, we're not the city of Tampa or the city of Memphis. We would talk about that and direct the ethics officer, but once it's set up, they would maintain it. Basically meaning they would be the one responsible for posting stuff, because I think we should, like the city commission, the mayor and city commissioners cannot post stuff to the city Twitter account. We ought to have exactly the same thing here to keep any one of us in a moment of insanity from, in a moment of passion from posting something on the board's Twitter account. It ought to all be vetted through the professional staff.
I'm just thinking maintain is that it tends to have an IT meaning behind it in this context.
Tell us a different word.
I'm trying to think of one.
Control will...
is responsible for, or...
We'll post on. And Mr. Chair, the reason behind this, in my opinion, is that is the way a lot of people get their information today.
Right, absolutely.
So we want to let the citizens know what we're doing in a way that they are accessing in today's world. No disrespect to the Tallahassee Democrat, Mr. Burlew. Okay.
The comment section would probably be I think you can turn off the comment section such that you're not having.
Yeah,
to
I would
have that-
suggest that that be something. But then let's look, what I would recommend, Ms. Meadows-Keefe, is that we look at the other social media platforms of other cities, such as Palm Beach, Jacksonville. See how how do they handle it?
How about this? On line 297, it says create and maintain. What if we, instead of changing those, it says, and other social media accounts, instead of as directed by the board, to change the as directed part? How do we fix this?
I think as directed is appropriate, but
Okay.
the main, I think, intent here is for the ethics officer to be responsible for the content. And if we can put that phrase in there to create and be responsible for the content of the ethics page.
How about supervise the creation and maintenance of an ethics page and be responsible for the content thereof?
That sounds good.
Okay, that's a great fix. So I'm going to take that as a motion to make a change in the published document by Mr. Payne. Ms. Graywall seconds. All in favor say aye. Aye. Opposed, nay. That is adopted. On item, where am I?
302.
On line 302, it says the ethics officer is an at-will employee. We remove the phrase without cause, so the at-will is, removal is with or without cause. And I think I'm talking about the right thing. Sorry, I got to turn the page. I have the page. Yes. That was the change, was adding the at-will employee, which was already the case. We're just being clear. Then I would like to make a motion that we add an item that actually we talked about when the attorney group sat down on between lines 301 and 302. After all of the other duties of the ethics officer, we insert L, perform such duties as are included in the job description or directed by the board. That kind of just catch-all that is good to have at the end of any list of responsibilities. As we all know from jobs, it was that 2% other duties as assigned that was what you really did for a living, not the stuff in your job description. Right. So I would move that. Ms. Graywall's nodding, so I'm going to take that as a second. All in favor say aye.
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 Opposed, no, nay. That is adopted. On line 333, and we do this again on line 346 for the board counsel. This was a suggestion that came from the front row at the last meeting, or it's a version of that. And what it says is, in addition to the annual evaluations, we will, at least every 5 years, the board will look at the ethics officer and look at the board attorney and make an affirmative decision that they want to keep that person. So beyond doing an evaluation, we could say, we could give the person a good evaluation and still say, for whatever reason, we'd like to go out and advertise the position. But it forces the board to make an affirmative decision to either say, yes, we like this person, we want to retain him and do nothing else, or we like or don't like this person, and we want to advertise the position and allow or not allow the current person to apply. Particularly with 6-year kind of term limits for us, it makes sure that each new board gets a bite at staff and decisions that were made on staffing by prior members. Ms. Graham.
You can see by my face over here. It's not that I don't think that it has merit. Can't we do that anyway? I mean, if we had an issue with any of the professional staff, couldn't one of us move that we reviewed it?
Absolutely.
So it seems redundant to me that we need to put this in policy.
Well, and we certainly can take it out. Again, it was an attempt to respond to a comment we had.
Yeah, I understand that. I just don't happen to agree that this is good policy, because I believe that it then forces the issue when there's not an issue. And when there is an issue, we should have the courage to deal with it.
Okay.
I know, I don't like to call last names, but that I asked to see if there were any other of those coalition, if there are any other examples of this, and I haven't seen any in policy in other entities such as ours or private or public. Because I think it actually kind of binds the hand of the board that if the individual is doing a good job, in my opinion, then we would like to keep that individual without having a date in the future where he or she is going to feel, that they're going to be questioned about their job. It's the board's responsibility to make sure that we have confidence in those that are serving the board. And either we do or we don't. And if we need to make a change, we need to make the change.
Okay, I'm going to take a motion from Ms. Graham to remove the new language on lines 333 to 341 and on lines 346 to 348. I think that's... No, I'm sorry. And on lines 358 to 369. Boy, somebody can't type. That would be me. 366. To 366. The identical, okay, so again, 333 to 341 and 358 to 366. That's the motion. We have a second. I have a second from Mr. Smith. All in favor of the motion say aye.
Aye.
Opposed, nay. Okay, so that passes. We're going to take those sections out, and at Ms. Graham's suggestion, we're going to act like adults and do the right thing.
That's right. That's what I have always said. Just do what's right.
Okay, on line 346 to 348, just specifies in the bylaws that we can appoint and hire additional contract counsel, which we've already done, and where I have to say I think we've already gotten great value, both in developing these and having, with Mr. Claypool, having Mr. Currington review some of the past actions when he was board counsel for us. So any objection to that? Seeing none. The next substantive change is on 367. Board counsel and any other legal counsel have to be members of the Florida Bar in good standing. No offense to the Georgia Bar or the D.C. Bar, but we want Florida lawyers. Just a little job protection. Any objections? Seeing none from a row of lawyers.
Mr. Chair, excuse me for interrupting again. We discussed previously the ethics officer being a member of the Florida Bar. Was there any further discussion about that, whether that's
we have talked about it in the past. It is not in the charter, and it would be up to the board to decide what they want.
Well, I do think, I don't think it should be required, but I do think that there needs to be an understanding if the ethics officer is in fact not a member of the bar, that he or she is not conducting responsibilities that would require, I think, having the legal abilities and skills and membership in the bar that allows you to conduct those responsibilities. Okay. And I think that Ms. Meadows-Keefe to date is doing some of those responsibilities because she is a member of the bar.
Right.
So.
And I think we get to that next month. We will look at the ethics officer job description and performance evaluation. Mm-hmm. And you've got copies of the current documents. Mm-hmm. So I think we address that issue in the job description. We can say, if you're an attorney, we expect this. If you're not an attorney, we expect this. And
Thank you.
And we can be very clear in the job description.
Perfect. Thank you.
Okay, so no objections to Florida Bar. Now, there's a lengthy section here on advocates, beginning at line 370 and running through line 382. The advocate, remember, if we get is essentially the prosecutor. If we get an ethics complaint when we go into a closed meeting and we determine that we're going to move forward with it, then it cannot be the board attorney because they represent us. So this is the attorney who effectively acts like the prosecutor. For the state commission, it's a deputy attorney general, I think, that they use. Mr. Claypool's nodding his head, so I must be right. If you have questions on this, Mr. Reed will answer them.
No questions?
No questions?
Seeing no questions, note without objection on that. Then we go to the next lengthy section, which is new from last month. These are the two really big changes from last month. And this adds the language on investigators. We talked, prior board members have talked a lot about, hiring investigators and could we pre-qualify, and that's something we'll have on a future agenda. We as a group in our Thursday meeting last month thought we probably ought to have some pre-qualified investigators. So if a complaint came in right after a board meeting, the ethics officer felt a need to roll forward with it, we wouldn't have to wait a month. We'd have some pre-qualified investigators, and the ethics officer could assign them to start work, or one of them to start working. This puts in place some of the board policy about investigators to be independent contractors, serve at the pleasure of. We would use them as appropriate in our investigative process that ultimately leads into our policies and procedures stuff. And again, Mr. Reed is the author on this section and can answer questions. Seeing no questions without objection, that seems to be okay with everyone.
Mr. Chair, I just
Yes.
had a quick, word choice thing actually on line 374. Just to go back to that real fast. Instead of serves at the pleasure, is there like behest or like some other word? There's just something very odd about the serves at the pleasure of the board. So
It's in the Constitution.
yeah, that's fair. Just as a vocabulary word, I guess. Oh, goodness. I'm so bad at this. This has not changed in 3 months. I was just saying on line 374, I didn't mean to go back to it, but where it says an advocate is appointed by and serves at the pleasure of the board, that just sounds a little bit odd to me, and I was just wondering if we could change that at the behest of the board.
And
It's a
we
very
have the same-
minor thing,
We
but
probably have pleasure in other places.
Same issue on 387.
Yeah.
I don't think there's much else pleasurable here.
it just seems like a very odd word, and that's the only...
Anybody have a suggestion?
Well,
Jane, you're our wordsmith. Do you have
I was just thinking behest would work.
Serves at
as well.
the direction of the board?
That's
Direction
what
also works, yeah. Pleasure
At
just
the
seems a little bit
direction.
odd.
Direction.
at the pleasurable direction? Just
Well,
kidding. It's a joke.
actually, one of these investigations may not be pleasurable, so it's a good word to
This
take out.
is true.
So
It
Ms.
would not
Graywall
be.
moves we change
They would
pleasure
not be
to
the
direction. Ms.
unfortunate
Graham seconds.
direction.
All in favor say aye.
Second.
Aye.
Aye.
No. Or opposed say no. And we've made that change.
That was
The
good.
change was
I liked that.
direction?
Yes, we're changing pleasure to direction.
Okay, just because I think the point was pleasures not only to the direction, but you also, it creates an at-will relationship. And I think it is somewhat of a term of art that's used commonly in government when you
I'm going to
deal with
look at my
boards.
synonyms. I'm going to Google it.
I see your point. It was two birds with one stone using pleasure. So direction gets one of those birds.
Pleasure synonyms.
Your HR meeting.
I will point out, this is not unique to our body. You hear, the Attorney General acts at the pleasure of the President. A staff director serves at the pleasure of a committee chairman. It's just a common
Well, now,
phraseology used.
if you look at 387, it says serves at the pleasure and may be relieved or replaced for any reason at any time. That sort of seems to define it. So if we say serves at the direction of the ethics officer and may be relieved or replaced for a reason at any time, that would seem to cover. So what if we did that on line 374? We say an advocate is appointed by and serves at the direction of the board and may be relieved or replaced for any reason at any time. We just pick up that same language, so those two sentences become parallel. Okay, so
I have whatever you want.
That works for me. The only reason I didn't mean to disrupt this for a term of art sort of thing, if everything that we have recommended to the city commission in the past has been trying to make it as accessible as possible, I feel like the bylaws should also reflect that as well.
I agree. So Ms. Grewal recommends we add that we make line 374 look like line 388. Ms. Graham seconds. All in favor say aye. Aye. Opposed, nay. Okay, so we have fixed that issue. You can ignore that's the 383 to 342. I had two other small issues, but they're included in the bigger issue that I've just pointed those out because they were different from that other document that was noticed. On line 477 to 482, Mr. Smith, we put a time limit of 3 minutes on comments that are determined by the chair, and it would be, hopefully would be pointed out by any board member, to be repetitious, to relate to matters outside the board's jurisdiction, or to relate to matters on which the board has previously acted or declined to act. So when somebody wants to stand up and comment on this document, they would get whatever time they needed. But when somebody's standing up because it allows them to be on camera and talk about something that this board can't react to, we can say, we'll listen to you for 3 minutes, in fairness, because it's a public meeting and you're the public, but we're going to cut you off after that. So it's a half a step in that direction, and see how that works. Ms. Graham?
And Mr. Chair, in fairness, you just stated something that I don't legally know, Mr. Reed, what legal rights to having your comments, if they're not an agenda item pertinent to something on the agenda, is there a legal right to have it televised, those comments televised? Sorry, I don't mean to put you on the spot. I think the answer to that question is no, but I think that at some point that these meetings should be meetings that if someone's tuning in on TV, they're tuning in because they wish to hear something about the agenda items, not items outside of the agenda. So would it be possible to turn the televisions off at the end of all of the discussion about their agenda items?
We contract with them to do this, and they're the ones that are responsible for the sound and such, and putting it out there. It would take a change in that contract that might be more trouble than we want to create.
Okay.
And the answer is no. You don't have a right to have. You have a right to. We have to take comment at some point, not even at the same meeting. There's Attorney General opinions on that. But no, it does not have to be broadcast.
When is that contract up?
Mr. Chair?
Ms. Medeski?
I just want to clarify that there is, to my understanding, there's no contract.
Oh.
We have a budget item that we allocate towards the broadcast, and we're charged by the hour or increment of hour.
Well, that's another reason
So
why.
at any point, the board could direct that cameras be turned off after the agenda business is concluded. So it's not a contract. It's just I get a bill that I approve every month.
Well, I certainly don't want to chill anyone's right to free speech or any of the issues that could result, but I think that that's something that maybe not now, Mr. Chair, that we decide, but would be something to be agended for a future meeting about whether it's in the board's best interest to, after the agenda is completed, turn off the television cameras.
Of course, in the past, we've had some of those comments from the public in the middle of a meeting.
Yeah,
So-
well, that's true. Well,
so-
we could then direct them to wait until the end if they're not talking to an agenda item.
Well, let's do this. The next time it happens, let's make a motion. Let's stop the person, make a motion, and see what the board wants to do. And in the meantime, we'll take a look. Mr. Reed may have information. Sorry.
Yes, the Supreme Court's discussed this issue, and it's later been codified by the legislature in Section 286.0114, public meetings, reasonable opportunity to be heard. Subsection 2 reads, members of the public shall be given a reasonable opportunity to be heard on a proposition before a board or commission. The opportunity to be heard need not occur at the same meeting at which the board or commission takes official action on the proposition if the opportunity occurs at a meeting that is during the decision-making process and is within reasonable proximity and time before the meeting at which the board or commission takes the official action. This section does not prohibit a board or commission from maintaining orderly conduct or proper decorum in a public meeting. The opportunity to be heard is subject to rules or policies adopted by the board or commission as provided in subsection 4. And subsection 4 essentially talks policies regarding the amount of time given, et cetera. So that's the relevant statute.
Nothing about broadcasting that I heard.
No, nothing here.
The reason I bring this up is this board is dealing with very significant issues. We are tasked with dealing with significant issues when we get the ordinances in place and our policies and our bylaws. And at some point, it is important that the credibility and integrity of this board is respected. And I recognize that there are important issues that people bring before us, but they do not fall within the jurisdiction of our board. And so, in my opinion, I think at some point we do need to have a conversation about whether leaving the television cameras on when we're not dealing with issues that this board should be dealing with is in the best interest of the board or not.
Mr. Chairman, if I may.
Mr. Reed?
I think the pertinent language that I just read is members of the public may be given a reasonable opportunity to be heard on a proposition before a board or commission. I think we've discussed whether the issues on the agenda or maybe foreseeably on a future agenda, and I think that we could probably distinguish there, and that's something I could provide some additional research on before the next meeting.
Yeah,
Thank you.
we can come back and look at that more. It may be that what we could do is if someone is intent about talking to us on things that are not within the jurisdiction of the board, that we go ahead, we let them wait until the end, we adjourn the meeting, we cut off the cameras, and then the board members can stay here and we'll be in a workshop. And any board member who wants to stay and listen to the issue can stay and listen to the issue. Because they're at that point basically asking us as citizens of the city of Tallahassee to agree with them and advocate as individual citizens to advocate for their issue, because we can't advocate as a board.
Right. And I think we as board members should commit to staying and listening. I don't think everybody, I do not think that would be in the best interest of the board for everyone to get up and leave at that point. I think we should commit as a board that we would stay. But again, I think the television cameras create an attractive nuisance in some ways that we don't need to continue, because I don't think that it reflects what this board was intended to do, which is to deal with the ordinances in place. And hopefully, do we have any update on when the ordinances will be addressed by the city commission?
Board Member Graham brought up a few issues. Just since you are relatively new to the board, it seems like you've been here forever now, but the board did make
I hope that's a good thing,
That's
Julie.
a good thing.
Okay.
The board made a policy decision rather early that it first held its meetings off camera, not in the chamber. The board decided it wanted to meet in the chamber, number one. And then number two, the board made a policy decision that it wanted the meetings to be broadcast for transparency. But there was no requirement that the meetings be telecast. So back several years, the board just decided we're going to broadcast. The board discussed, I guess during our blue sky discussions, do we want to continue? And I think the consensus was yes. The second piece of your question was when the commission anticipates dealing with the recommendations. The information that I received is that it would be at the earliest September. Definitely affirmatively by the end of the year. So there's a window there, but we're hopeful that it's September.
And as I understand, the city commission does not meet during the summer. When
Well-
is their next,
I think they take 1 month off.
They take
only 1 month?
July 10th, I want to say, is the last commission meeting. And then they take the month of July and August off, and then they meet in September.
Not us, we're here every month.
Yes, and there was a
Yes.
question, I got a question today, is the board ever going to take the summer off? And my answer to that was probably not, as long as Mr. Herring is the chair.
And he's here we
And
love
he's
him.
here for the duration.
That's right.
So
Well, if everyone would promise to never have an ethical lapse for a month, and we could take a month.
Okay. Oh, okay, I would love that.
We've never missed a month.
Okay, so Ms. Graham, you've added an item, a future agenda item just now.
Yes, I'm sorry.
Yes,
for
we've got
the
you on that.
conversation.
And that's a good issue, because we are not simply a way to get on TV. We are an ethics board. Any objection to the new language on 477 to 482? I think there are probably people who'd want to go farther, but I thought this was a good first step. Okay, 489 to 493 is new language. This had previously related to minutes. Now we've picked up language about the results of any closed meetings that we would have on an ethics complaint. And I would need to make a motion that on line 490, we change written minutes to transcripts. That's simply an error. We added transcripts up on line 483, and it did not get repeated. So on 490, written minutes needs to become transcripts. And Ms. Graham's going to second my motion. All in favor say aye. Aye. Opposed, nay. That one minor technical change. Anybody have a problem with just this saying that we make our transcripts available, which legally we're going to have to do anyway, but it just recognizes it here, and that transcripts are different from minutes. Line 507, then this is a relatively meaningful change. We're going to conduct our meetings in accordance with our bylaws and Florida law. We take out Robert's Rules of Order. For any of you who've looked at Robert's Rules recently, there are 600 or 800 pages in which you can find any position on any matter that you want. It simply they create a way for anybody to object to something. So what we're saying here is we're going to do things pursuant to our bylaws and the law, and after that we're going to operate the way the majority of the board members want to go. So we're trying to make sure that we do what you guys want to do, what a majority of you of us want to do in pursuing things, and our attorneys will jump up and down if we're about to do something unconstitutional, illegal, immoral, or fattening, and stop us. Okay? Line 546 to 563 has a prohibition. This is the ex parte communication prohibition relates to ethics complaints. We talked about this before. This is a revision of the prior language. Previously, it could be read to say that no board member could talk to anybody about anything that would come before the board ever. So if somebody wanted to suggest that the board ought to change the times of its meetings, you couldn't talk to them about that. Well, that was obviously not what we meant. We were trying to say when we're in a quasi-judicial mode. And then we add a phrase here at the end at recommendation of counsel that any discussions we have in a public meeting with someone, say, standing at the microphone, that doesn't violate any ex parte communication thing, because we're obviously in a public meeting. So this, again, is here to protect the board members and make sure that we don't inadvertently violate our own bylaws. So, no, I don't see any objection on that. 588 to 595, all decisions by a majority vote, and abstentions do not count toward a quorum. So if we had 4 members and somebody said, I have to abstain pursuant to the law, I can't vote, we would lose a quorum. We would not be able to decide that matter at that time. Now, typically that's not going to be a problem. If we have 5 people and somebody has to abstain, we'd still have 4, which would be a quorum. But I have had numerous discussions with our attorneys about making sure we protect ourselves with a quorum, because we've had times when we had 5 of 7 members, and if somebody's absent, I mean, we've been close a couple times. And we'll continue to have those discussions about quorum, but we think that sometimes when you abstain, the law says you don't count toward a quorum. There may be other times when you're allowed to abstain voluntarily that you could count toward a quorum. We're going to continue to look at that legally, but this is a pretty conservative position, but again, protects the board members and makes sure that when we take a vote, we're sure that we've got a good vote and we don't have to negate it and come back and redo it at some point. On line 612, this creates a standard for recusal in quasi-judicial proceedings. You have to decide whether, if allegations are made that you wouldn't be impartial, whether the allegations create an impression that a board member's impartiality might reasonably be questioned. It was just to try to have some standard for measurement there if we're in a quasi-judicial proceeding and someone is worried about impartiality and recusal. So obviously, we can change that, and we start having a series of ethics complaints we may find on some of these things. We want to come back and look at them after we have more experience or we have specific experiences, but that one seemed to be a good generic phrase. 648 to 671, all the language stricken is basically moved to the proposed policies and procedures. The same on 727 through 1035, it's moved to the policies and procedures, and Mr. Reed will cover those next. On 1041 to 1045, we talk about the policy that we've had for a long time, which is that amending the bylaws takes 2 meetings. Typically, you announce it in the first meeting and adopt it in the second meeting, and you can amend it in either meeting. But this says that if we want to move fast, we could do it in one meeting as long as the amendment is noticed, so everybody knows it's coming, and we decide to make that amendment to the bylaws and adopt it by a 2/3 vote, that we could do it in a single meeting, because we recognize there might be times that we want to be able to act expeditiously, and we don't want it to take 2 months to make a bylaw change that we think is important. Now, obviously, we can waive our bylaws at any point, but if we really want to make a serious bylaw change, the board ought to be able to do what the board wants to do. So that's the only place we've got 2/3 vote anywhere anymore. And that would be the end. So, did anybody have any other corrections, additions, comments, questions?
Very good.
Jello on the wall. Okay, so what I'd like to do is move that we adopt these bylaw changes I'm sorry, Mr. Reed.
Just from a procedural standpoint, and I know we discussed this briefly, but since changes have been made today, there is a rule about a time that the proposed changes need to be before the board. We do have the opportunity to waive. We could just procedurally, by a 2/3 vote, waive the rules. It would be specifically Article 12, Article 12, Section B, just to waive the rules to make sure we're in the proper posture and not open to any collateral attack at a later date.
These were noticed last month. They're noticed this month, but we've made some substantial change. One of the changes we make is that you can do it in 1 month. So living within the bylaws we're about to adopt,
Right.
which aren't in place yet, what I'd like to do is move that we get a 2/3 vote to amend these, and then I'm going to move that we adopt them as amended tonight through a series of motions. So the first is I'm going to move for a 2/3 vote to allow us to move forward with these tonight and adopt them as final. And Mr. Payne seconds. All in favor say aye.
Aye.
Aye. All opposed, nay. So it's unanimous. So we got our 2/3. Now we're on a motion to adopt them as amended through this series of motions. All in favor say aye.
Aye.
Aye. Opposed, nay. They are adopted. So our bylaws are done. I would like to make one last motion, and that is that if staff find any purely grammatical or spacing kinds of issues, if there's something that's indented twice that should be indented once, or a period in the middle of a sentence that was obviously meant to be a comma and none of us have eyesight to see it, that staff be allowed to make those kinds of purely technical, non-substantive changes.
Absolutely.
Okay, without objection.
Aye.
On everything I ever do.
On everything, yeah.
Okay, that moves us to the next item on the agenda, which is the procedures, our draft administrative procedures. And Mr. Reed is going to walk us through those. So, Mr. Reed, you're recognized.
Okay, thank you, Mr. Chairman. I believe in your packet, there is a draft procedures as well as a traveling amendment. I think the traveling amendment can be discarded because that is properly addressed in the draft that is before you, and this was based on some discussion at the last meeting. our friends from the coalition raised some issues that were very legitimate, and we addressed those in the draft that is now before you. So I could just go through page by page. There are some significant changes, but I think they're all for the best. In the first paragraph, we just corrected a couple of typographical errors that just remained. On page 2, line 48, this is addressing an issue that's pending before the City Commission. In the case that they didn't adopt the ordinance changes that we proposed, this simply leaves an out where it's only if authorized, so it is pending before the board. So we added that language there as well. Paragraph 4 is the board shall refer willful violations of the ethics code to the state attorney. This was removed. We're already required under the bylaws to require criminal matters to the state attorney, and this was stated to read ethical issues. They may not necessarily be against the law, and the state attorney might wonder why we're bothering them with all of these willful ethics complaints that don't rise to a crime. So we removed that paragraph. On page 3, line 78, we tried to broaden the issue on when the board would abstain from issuing an advisory opinion. It's any legal matter as opposed to simply litigation. That could be if there's another ethics complaint may be pending before the state. Litigation may or may not necessarily cover that. We feel we kind of broaden that issue with the term legal matter.
Okay, let's pause. Any questions so far? Okay, so if you have a question or concern or comment, just speak up, and Mr. Reed's going to otherwise just roll.
Okay.
Sorry, John, go ahead.
No, I appreciate it, and I'm talking a little fast. That's kind of how I talk, so go ahead and wave at me if necessary. On page 4, line 106, we do allow the ethics officer to proactively reach out and try to obtain more information if that is necessary to provide a meaningful advisory opinion. Also on page 4, we kind of went back and forth last week on when an individual can withdraw the request for an advisory opinion. The way it was originally drafted is that once we were 10 days out from a meeting, they could reach out and say, you know what, never mind, I don't want that opinion. We decided to say that they could withdraw at any time. Now, it's important to point out that this in no way removes it from public records. It will always be a public record, whether it's issued or not. Once the request is made, we fall within the confines of Florida public record law. However, if there was an issue where I think an example we had used, if they were seeking to enter into a contract, a city employee wanted to enter a contract with a third party, and they wanted to seek an opinion to make sure they didn't violate the doing business with or conflicting contractual relationship provisions of the proposed ordinances that we sent forward, and then later found out there was a non-disclosure agreement that they'd be bound to. This would give them that opportunity to come forward and withdraw. They still would be a little stuck under Florida public records law unless they could find an exemption under the state statute, but that at least gives them right up until the meeting to say, you know what, never mind, I think I'm fine without that opinion. So that was a significant change from our last meeting. Let me see. Okay, in page 4, what we ended up doing is we kind of merged paragraphs 1 and 2. The way it's stricken, and it's supposed to continue. So it says, once jurisdiction and official factual information are determined to exist on the face of the request, and then it's comma, and then you move down to the independent clause that was previously in paragraph 2, which is a draft advisory opinion letter will be written by the board counsel and reviewed by the ethics officer. So we felt that it was a little repetitious. We were able to consolidate those 2 paragraphs that I think achieve the same goal, and then we renumber the subsequent paragraphs. What was previously known as paragraph 4, we removed. This was an issue where it would allow the ethics officer, I think working with the board counsel or just with the board chair, to issue an advisory opinion without coming before the board if it was so similar in fact to a prior advisory opinion issued by the board. It was felt by those within the work group that every issue should come before the board, whether it's a very similar set of facts, because now we get into a little bit of subjective judgments. So we removed that, so now every advisory board that's issued by this board would have to be approved for publication by the board. The opinions, we removed the consent agenda. We originally had where advisory opinions could be placed on a consent agenda and we could get through them in one shot. We decided to remove that, so every advisory opinion would be its own separate agenda item.
And let me interject here. That's also based on the fact that we have never had a consent agenda. And we don't have any reference anywhere else to a consent agenda. I think given the nature of the work this board does, that a consent agenda is just a bad place to be.
Okay. Continuing on page 5, we do have provisions where the ethics officer and board's counsel are able to somewhat interact with the person requesting a response to an advisory opinion. We did want to specify that it's informally, so that way we don't delegate too much power to staff to issue what could be viewed by an independent third party as an opinion when it is in fact not one. We then move down to page 6. This deals with the issue of self-initiated and filed complaints. Now, Rule 1.03 in our last meeting was self-initiated complaints. 1.04 was filed complaints. Those are filed by individuals with the public. We decided to merge the paragraphs because the procedures were identical and it was very repetitious. So what we did is we ended up keeping Section A remaining as the self-initiated claims, and we provide procedures in which the board could meet, decide to initiate a complaint, and then how they would get to that next step. Obviously, board members can't speak to one another because of Florida's sunshine law, and it's an issue that would not be appropriate to discuss in the sunshine because once it becomes a subject of a complaint, it's subject to the public record exemptions available to us under Section 112.324. So we've provided a provision where, while in closed session, the requesting board member shall move for consideration of a written proposed complaint, and after the board deliberates, they shall take a vote to take the following action necessary here. We did state that I think it's the decision to initiate. Previously, it was any discussion. We wanted to make sure that we didn't catch any members in a provision where you might raise an issue that at the moment you say it, it's not being thought of as a complaint, but as it's further articulated, you determine this may be an issue that's subject to a self-initiated complaint. So we wanted to make sure that the discussion that must be done in a shade meeting would only be that initiating a complaint and not the preceding discussions that may eventually lead to a self-initiated complaint. And that was more for the protection of the board. Once we get to that point, they will take, the board will then take the following actions. They'll have something in writing. They will then determine whether the complaint is legally insufficient. If it is legally insufficient, the ethics officer shall prepare a written report declaring the potential complaint to be dismissed and the relevant reasons for why it is legally insufficient. We then have the next section, which deals with what happens if we find that it is legally sufficient, and then essentially we'll move to the next step that a third-party public complaint would also follow, which is our preliminary investigation and probable cause hearing. So if you then notice, I've removed all the sections underneath that deal with preliminary investigation and probable cause hearings. That's because that same language was in the following sections, so we immediately just pick it up there. So we eliminate the remaining sections in sections 103. I then remove the heading for Rule 1.04 and rename that that's Section A to Section B. So now we're still continuing under 1.03, which Section A dealt with self-initiated complaints. Section B now deals with those complaints that are filed with the board, and we provide procedures there. We then Paragraph 2 is changed to Paragraph C. That deals with our legal sufficiency. And one of the issues that was raised, I think, at the last meeting by our friends with the coalition was the language dealing with the personal knowledge of the complainant. There's conflicting language among ethics boards around the state. The state ethics board does not have a personal knowledge requirement, so we decided to remove that language. So now we would have sections A, B, and now a C, with C being removed and D moving up. And this would allow someone to then state that based on knowledge and belief that they would be making their complaint under oath. And I think that at our next meeting, we'll be discussing, there will be a number of forms that we'll be asking you to approve at our July meeting. One of those will be a revised complaint form, which will further articulate this, not just for our benefit, but for the benefit of those that file a complaint.
Mr. Reed?
Yes.
I appreciate our conversation about this yesterday, and I agree with the change, but I also want to make sure that everybody still understands that this is going to be a sworn complaint, regardless of whatever level of knowledge you have or how you gain that knowledge, it will be a sworn complaint, correct?
Yes.
Okay.
And that is a requirement, I believe, under the charter. So we are.
Of the ordinance.
The ordinance, I'm sorry. Yeah, I knew it was somewhere above our pay grade, I knew. So, and as I had mentioned, I think yesterday, these are our procedures that we could change. This is not something required to go to the city commission. Right. If we determine that maybe we've made it too strict, right, and we've created somewhat of a chilling effect, we could open it up. If we see abuse is occurring, we may wish to tighten that, and that's something that could be changed as we proceed. I then adopted language at the bottom of page 9, and this is language that was derived primarily from, I think it's the Florida Administrative Code, as well as the ordinance from Jacksonville that talks about the knowledge and belief, and it says that it may constitute a violation of the ethics code. Really, it kind of lowers the bar to allow a complaint to get through the legal sufficiency stage. And that is, like I said, consistent with what the State Ethics Commission does. And again, like we had done before, with the advisory opinions, we added a provision where the ethics officer may request additional information from the complainant, also consult with the board counsel or obtain information from public records that may be available to her to make that determination. Now, one item that I think Mr. Claypool brought to our attention was that I think the issue of legal...
By the way, let me interrupt. I'm going to move that we add this item. So this is, he's going to suggest a new paren 5. I'm going to move that, so you want to pay attention to what he says here, because we'd be amending the document before you.
Yes, and I think that we could just relate back to prior language. Essentially what we have here is we have what happens if you find legal sufficiency, but we didn't include language that says what happens if the complaint from the outside doesn't have legal sufficiency. We did, however, address that with the self-initiated complaints, so I think it would make a lot of sense for us just to take the language or something very similar to it, which is found on page 7, beginning at line 208, where if the complaint here, not a self-initiated complaint, but one filed with the board, is found to be legally insufficient, then we would include language, the ethics officer shall prepare a written report declaring the potential complaint to be dismissed and shall state all relevant reasons for the finding of legal insufficiency. Does that sound suitable, Mr. Chair?
Yeah, so this would be adding language. This language is already in this document as it relates to board self-initiated complaints. We're just parroting it in the part about complaints that we receive from third parties so that the two provisions are parallel.
Okay. Okay, and do we need to do a motion for that, or do you want to do it all at the end?
Okay, so I'm going to move that we insert that as a change to this document. Do I have a second? Ms. Graywall's nodding, so I'm going to take that as a second. All in favor say aye. 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 Opposed, nay, and that's adopted. Mr. Reed, you're back on.
Okay. Page 10, we then move to preliminary investigation, probable cause hearings. You remember there's the language that was stricken from the prior section, because now we get into it after we've addressed the issue of outside complaints and the legal sufficiency standard. We then determine how we will find a probable cause. It'll be based on, instead of findings of fact, which was in the original draft, as Mr. Claypool pointed out as his recommendation, finding of fact is really something that should be left for the administrative law judge, and what we would want to base that finding on is the narrative investigative report that would be prepared by our investigator or by our ethics officer if it's not a very detailed complaint. Most of this is, I think, a little stylistic, nothing too substantive. Moving to the bottom of page 11, we discussed the notice of rights. Now, I think the discussion that we had is the language that was previously here somewhat mirrors the approach that you take through a Chapter 120 case that goes before DOA. We, as a board, have decided that we will be using the Division of Administrative Hearings to serve as our independent fact finder, but we would be operating not under Chapter 120, but under a contract. So the procedures that were here would essentially mimic those in Chapter 120, because we feel that would be most convenient for the administrative law judges. What we would like to do for the notice of rights is, instead of putting into ordinances, we are going to adopt a form, and we will have a standard notice of rights form that is sent with every complaint to a respondent. So they will then be laid out with all of their options, which would be to dispute an issue of material fact and request a formal hearing, concede to the facts and request an informal hearing, or they could just waive their right to a hearing. We would also add a separate provision, which was not listed here, where we would give them the opportunity to place a matter into abeyance. If they wish to dispute issues of material fact, they would have the option to choose to place into abeyance so they could enter into a settlement discussion with staff, so it doesn't necessarily have to be litigated if we could find a reasonable resolution.
And that notice of rights will be on a separate form. We decided to take the language out here, so you will see that form next month, along with a couple of other forms that are referenced in these documents. So there is a small tail into July on these, but it's simply for a couple of forms that hopefully we won't need over the course of the next 30 days.
Okay. And then moving to page 12, we discussed the issue of abeyance. This is the board would have actual knowledge. This was to make sure we didn't catch ourselves where, if at a later date we found out there was a separate ethics investigation or an issue before law enforcement, and we've already started. This says it's when the board learns that allegation is being investigated elsewhere, we'll place the issue into abeyance. We then, since we merged rules 1.03 and 1.04, we then renumber 1.05 to now 1.04. This deals with the procedures for public hearings, recommended orders, exceptions, final and remedial orders. As we previously stated, we're going to propose a notice of rights form to be approved by this board, so we remove the section that a respondent be required to file a petition or a request for hearing, and instead they would simply just have to fill out the notice of rights and send it in within writing within 20 days of service of their finding of probable cause. Everything else that remains is unchanged from our last meeting. And our judicial review, again, we renumbered the section, and that simply articulates the fact that any finding by the ALJ that comes back to the board and is issued by this board as a final order is subject to appellate review with the circuit court. That's all I have, Your Honor.
Any questions, Mr. Reed? Any questions on the document? Okay, I'm going to move by 2/3 that we take up this, although this is our second time looking at this document, we'll treat it like we would the bylaws, by 2/3 that we go ahead and adopt this, because we changed it tonight, adopt this as presented. So this is just the 2/3 vote to get us to the final vote. So Ms. Graywall's nodding, so you're second again. Motion that we take this up and adopt it as a final document tonight. All in favor say aye. Aye. Opposed, nay. Now the motion is that we do adopt this document as, I think there's just the one amendment, right, Mr. Reed? Adopt this document as amended tonight. All in favor say aye. 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 Opposed, nay. And it is adopted as the final document. And again, I would move without objection, hopefully, that I'm going to, I apologize for not getting you on the last one, but we'll come back if we need to readdress anything. To move for staff to make any, if they find a typographical error or spacing error, to fix that without objection. And I apologize, Mr. Wilcox, I should have called on you on the last item. If there's anything we need to go back to, we will go back to it, sir.
Sure. Thank you, Board Chair Herring and board members. I'm Ben Wilcox on behalf of Citizens for Ethics Reform, or Ethics Coalition. We would like to express our support for both the bylaws and the administrative procedures that you just adopted. We thank the board chair, the board, and the legal team for all of the hard work you have put in on these agenda items. We also thank Board Member Graywall for your service and wish you the best in your future endeavors.
Thank you so much.
Okay, with that on the agenda, we are at our break. So it is 5:22. Let's come back at 5:45. We have more than a quorum. I have a letter that I don't particularly want in front of me, Ms. Graywall, but thank you, I suppose.
I don't want it either.
Where are we? We are, Ms. Meadows-Keefe, you are going to do a little ethics education with us here.
I am, and I'm going to try to migrate effectively down to that podium, and it should be, God willing, queued up.
So we are on item 8 on our agenda.
Now my quandary is going to be how to advance the slides. But does anyone have any insight into that? Oh,
Is there a remote?
there's a remote, and I'll meet you halfway. So just a little background, Mr. Chair, if I'm still recognized.
You are?
All right. The board annually conducts ethics education for itself. So we talk each month in my report about the various education opportunities that I present in the community, citywide, and to advisory groups. Always trying to tailor the education to the group. We feel it's important that board members also get annual ethics education, and at the beginning of the board's history, there'd be a longer time for this. It may be like a whole meeting, and we would have like Pat Gleason, and we had ethics commission staff come. But this chair a few years ago started the ethics moment concept, where we'd present like a case study or something interesting so that the board could learn a little bit at each meeting. But it's very important that the board members all learn not only about the city and, say, state ethics law, but why special education is needed for local ethics boards. And I'd encourage all of you, as I always do, to actually attend city commission meetings if you can. I always see Mr. Payne, not to shout him out, but he rarely misses a meeting. And I think that's one reason he ended up sitting on the board. So I don't know if he regrets going to all those meetings or not. But you learn a lot about the city and about the function of the board by going to the meetings. So being involved is important, learning who the leadership is. And we've gone through exercises in the past where we've had the city manager, the city attorney, different assistant city managers come and describe their job functions to the board. This board has turned over quite a bit, so it may be time soon to actually do that again so that you put names with faces and actually relate to what these folks do every day. So if you get a complaint or you hear something about the individual, you can relate to that. So until you actually go to the meetings and people ask, well, why do you go to all these meetings? It's because I learn about the interplay of the different individuals and the relationships and what types of things the city's trying to do. So with that as a background, there was an OPAGA study, and I think I included that with you all's materials. So advance, please. Are we on? Well,
This is the
oh, it's working now.
2013 study.
It's a 2013 study. And so, I mean, it's not completely up to the minute, but it is cogent in that it looked at the Palm Beach Ethics Commission and things that it did well, things that it could improve on. But the thing that's applicable is that there is no one-size-fits-all education for ethics in any organization of any significant size. And so if you're going to teach about ethics concepts, you're going to teach about those differently to folks that might work in fleet management or mechanics or parks and rec. So one thing we tell the parks and rec kids is, or individuals working there, is we don't let your friends into the pool for free. I'm not spending a lot of time talking to them about voting conflicts and things of that nature because that doesn't relate to them and what they do. We instead try to tailor it to their job function. Some principles are consistent throughout, that we don't steal equipment from the city for our own personal business. And some training is even done one-on-one. So as people come to you with questions, you may actually take time to educate someone on an individual basis on the question that they're asking, and that folks learn to apply ethics concepts by actually doing them. So as there's been ethics curriculum developed by my office and with this board's assistance, we've attempted to tailor education to the different groups. But going to the study that is, again, sort of dated, but it's the only one of its kind that I could find actually in Florida that looked at an established ethics commission. And you've heard us talk about the Palm Beach County Commission on Ethics as we've looked at our ordinances and our recommendations. So OPAGA undertook this study in 2013, and the way the Palm Beach County Ethics Commission works is there's actually 38 municipalities in Palm Beach County, and they all fall within the umbrella of Palm Beach County. So the municipalities, as they have ethics complaints or issues, they bubble up to the county. So usually when there are local ethics boards, they start at the county level and work their way down to individual municipalities. Here in Tallahassee, it is the Tallahassee City Independent Ethics Board. Leon County does not have a board. They recently considered ethics laws and ordinances themselves, but this board does not cover Leon County. This actually refers back to what the chair was saying before, that there's some community confusion sometimes about what this board has jurisdiction over. So I had a gentleman call me about a community development district because he understood that it had a relationship with the city. Yet this board, I didn't ask legal counsel for a formal opinion, but it was my opinion that this board would have no jurisdiction over a member of a community development district. So this board deals with city matters only. So if it's about a county commissioner, a county issue, that would not be for us. But in Palm Beach County, we have Palm Beach County and 38 municipalities that it controls. And each municipality actually pays money to the county to support the functions of that board. And OPAGA found some good things about it. It had a lot of best practices. Education was diverse and specialized. And then they also emphasized diversity in board member selection. And those board members were separate from elected officials. There was role definition, and in OPAGA's opinion, there was appropriate separation. But there was some confusion with that board over what constitutes a conflict of interest. And as we've talked about here a lot, whether a conflict is actually real, when you analyze it, it constitutes a genuine conflict of interest, or it's something that's perceived in the community. So OPAGA really believed, in the next slide, yes, that answers exist through education. So that's kind of a foundation for why the board does take time to educate its members. It was important for those Palm Beach County Ethics Commission members to understand the workings of the county before they could be really effective board members. So often people are appointed to a board, they sit on a board, they're diligent about reading the meeting materials, but they may not have an actual understanding of the mechanisms that apply every day as the folks are doing their jobs. So OPAGA recommended that the board members actually get more education about the municipalities and what constitutes ethics violations and what does not. OPAGA says if you want to apply the code to others, such as vendors and lobbyists, you must train them. So there has been some discussion in the past about whether we would apply the city ethics code to our vendors doing business with the city. And if that was something that was pursued, there'd be an affirmative obligation to then educate those vendors on the city ethics code. You wouldn't simply put that into contractual language and leave it there. They would anticipate that there'd be a training opportunity of some kind for those vendors to learn about the city ethics code. And similarly, if you're applying it to lobbyists and even candidates. So it's easy to say we're going to apply this to people, but they need to understand what that means. And my suggestions to you all pursuant to this are that you perhaps take time to attend a monthly scheduled employee education, you attend at least one commission meeting, and if things going on in the city, if you read them in the news clips that I send, you have a question about something that you call, and I can try to answer the question or set you up with someone that can. So what I gleaned from this that was important for me to emphasize to you is that for you all to be effective board members, it's important for you to understand the mechanisms at work in city government. So that's kind of the why. Any questions, observations, Mr. Chair?
Seeing none, roll forward.
We're rolling forward.
Roll on.
Can we get to the next one, which is, I'm not going to wait for the slides. I'm going to just proceed. This is the legislative update, and I am guessing that the chair could probably talk to me about some of these if I get them wrong. But one that passed and was approved by the government, or by the governor, is that there we go. Local governments are to establish and maintain internal controls, and municipalities are going to maintain specified budget documents on the government's website for a designated time. The other thing that's interesting about this is that it also defines the terms abuse, fraud, and waste to be used in the establishment and maintenance of internal controls. And I know when we were talking about our ethics and fraud hotline, we got into a discussion of what fraud, what waste, and what abuse actually was, and if that was more properly an auditor function or an ethics function and exactly what's meant by those terms. The bill also expands the definition of local governments to include tourist development councils and county tourism promotion agencies, and expands the Auditor General's authority to audit these entities. So how they defined abuse, fraud, and waste may be informative. Abuse means behavior that is deficient or improper when compared with behavior that a prudent person would consider a reasonable and necessary operational practice given the facts and circumstances. And actually, the term includes the misuse of authority or position for personal gain. So it seems as if in the abuse area, there may be some intersection between the two concepts. Fraud basically means obtaining something of value through willful misrepresentation, omissions, disclosures in financial statements. Those are more related to numbers. And waste means the act of expanding or using resources unreasonably, carelessly, extravagantly, or for no useful purpose. So I think we're all aware of instances where that can occur. Again, the governor has signed that, and the bill is effective on July 1st of this year. The next one, this is I think we've talked about it a little bit here in our board meetings, the financial disclosure forms being electronic. And the goal is that you'll be paper-free by 2023, I think is the little catchy phrase they've tried to use to make this appealing. But they are going to be developing and testing an electronic disclosure filing system. So the Ethics Commission got tasked with a number of things this past year. The Constitutional Revision Commission has tasked the commission with defining what a disproportionate benefit is, which is highly unusual, that a Constitutional Revision Commission would basically tell an agency to do rulemaking, and to do rulemaking to define a term. Here, the Ethics Commission is now being asked to develop this electronic filing system for these very important financial disclosure documents. And you can understand why this would be desirable, that they're more readily accessible by the public. They're reducing paper and the risk of things getting lost. And there was a part in the bill that said that this would also be applying to local governments, but it was brought to my attention today that there was some confusing language in the bill that seemed to indicate some confusion about whether this would actually apply to the local governments or not. Everyone just assumed that it would, but there's actually some language in there that may need to be cleaned up last year. But the other thing that's interesting that they're doing here is they emphasize several times in the bill that they do not want your confidential information. So things like your social security number, they don't want to be responsible for those. So they're asking for those to not be included. So any software that's developed will have to kind of intuitively know that there's certain things like your bank account number that should not be distributed. There's also public records exemptions for that information so that folks can't obtain that from whatever filings that you have. And then as they are building the system, any access codes that may be utilized in building the system or logging onto the system, those too are held confidential from public records. The other item this year had to do with the automatic fines that attach if you do not file your ethics forms on time and then the automatic fines accrue, and then you do not pay them. You have been able in the past to dispute your fine if you show unusual circumstances. So I think people have been creative or maybe lazy about what that is. So people have said it's an unusual circumstance. I don't monitor my email. Well, I probably have 70,000 emails in my Gmail because I buy the extra storage, so everything's just there. So failure to monitor email is not unusual because there's probably a lot of us that don't. So they're taking that away as an excuse. And then also you fail to notify the Ethics Commission of a change of your physical or email address. So I think they took some of the most common excuses that they were tired of hearing and said these aren't unusual, that you need to remember to change your address and your email with the Ethics Commission so that it can communicate with you. And this is also to remind those that are sitting here to which it applies. Renee is not here, but the Form 1 deadline, if you have not already filed one, is coming up July 1st. And you do file those right now at the Supervisor of Elections office, which has moved. This is your public service announcement. It used to be downtown. Now it's in a shopping center at the corner of Appalachie Parkway and Capitol Circle, where the Big Lots used to be. And then Ms. Graywall, within, I think, is it 60 days, as you complete your service on this board, I know you probably just filed your form, you need to file a closeout form before you leave that indicates that you're now done. And so you need to actually complete that after your board service. Oh, and this actually talks about the public records exemptions that I was talking about before for Ethics Commission electronic filing. This next one, to my mind, or to my best knowledge and belief at this point, has not been signed by the governor yet. And you'll recall that community redevelopment agencies have been something that have been quite newsworthy. The legislature, taking note of this, has passed legislation requiring 4 hours of Ethics Commission training for CRA commissioners, and that they must use the procurement process of the city or county that created the CRA. They want transparency in the CRA maps, and that beginning March 1st, 2020, each CRA must file with the city or county an audit, enumerated performance data, and assessment of whether the CRA had met its goals. And there is a sunset provision as well that there is going to be a termination date for CRAs, and it's quite far in the future of September 30th, 2039. There is a mechanism in place to expand that. It also includes a provision for termination of CRAs that have been inactive for 6 years. It talks about the trust fund, and it may only approve funds pursuant to a budget that's been approved. So, and now there is a requirement for a separate standalone audit of CRAs with more than $100,000 in annual revenues, and will specifically require the auditor to opine that all expenditures were legally authorized. So there's some emphasis now on more accountability for CRAs. And again, I don't believe that one's been signed yet.
Questions? Next.
Finally, Board Member Graham, several meetings ago, did ask for some clarification related to public records policy for the city. And I know there's a presentation on that will be queued up really fast and shortly. Oh, here it is. And I believe it's actually included in your board materials. You should have that. Keep it for your handy reference if you would like. But they were recently revised last year. There was a particular focus on text messages. We have a reporter in the audience who I think is familiar with some of the issues that were going on. And part of the policy was part of a settlement of a lawsuit related to that. So the city did improve and change its public records policies. And the highlights of those are to be fast when fulfilling public records request, and that relates to all kinds of requests. And it also relates to the annual training that happens for city employees. So we do roll the public records education into our ethics education, because the Ethics Commission, as part of what it requires for elected officials every year for its 4 hours of ethics training, they require a component on sunshine and public records. So,
Julie, can I ask a question?
yes, ma'am.
Is there a recognition that, I don't know how the city of Tallahassee operates, whether they provide cell phones or whether you have personal cell phones that you use for public business and then you let the city know, get reimbursed? I don't know how that works.
Related to cell phones, the city will and does provide you with, if you're in a job that requires it, a city cell phone, and you are required by this policy to be utilizing that phone for your public business. I think an issue before was that people were using, employees were using their personal phones for both personal and for city business. And when public records requests would come, you wouldn't necessarily receive all of the public records that may have been housed on an employee's personal phone. So I guess some additional phones were purchased for people. There was a requirement that you're not using your personal phone for the city business, and that way the city can capture those text messages and be able to produce them readily when there's a request made of the
And
city.
what does the city do if an employee has a personal phone and a city phone, but they're using their personal phone for city business? The employees do know that just because you use your personal phone does not exclude anything on that phone from a public records request, if it's related to city business.
We teach, and I know it's been said here, but all employees know that it's not the way you send it or the means by which you send it. Pat Gleason likes to say carrier pigeon. It doesn't matter. It's the content of the message that determines it.
Okay.
So people do realize that, and they're advised if they do get those types of communications on their personal device, that they're to forward those, as we've talked about before. And I just did want to say that what the city did to kind of turn the ship around, they made lemons to lemonade, in that the Florida Bar Journal, or actually in May of this year, wrote up the city for having basically a best practice for public records requests. So I think that's kind of the crucial part when you have a slip up, that you take a look at it, you figure out what the problem was, and then you take affirmative steps to fix it, so hopefully it doesn't happen again in the future. So this was an abbreviated ethics education that we started last month with Mr. Reed's stuff on whistleblowers. And now we are complete, and we'll be back to ethics moments in the future if there are no more board member questions.
Seeing none. That would complete item 8. Item 9 on our agenda is the follow-up to whistleblower. Last month, there were questions. I think Mr. Reed did a great job of explaining to us how whistleblower works, what the city's current policy is, that the whistleblower protections would extend to those issues that you would raise with the city manager because there's not an ordinance. And we talked about the fact that it would be good if this board could be able to offer whistleblower protection in appropriate circumstances. And so we said we come back this month with something. What I have done is drafted, you should have a one-page letter to the city that says this ethics board recently learned about whistleblower stuff. We note how the state law operates. We think that the City of Tallahassee Ethics Board should be included as an entity authorized to receive whistleblower complaints and thus offer whistleblower protections. We have looked at other local governments, and we point in particular to the Miami-Dade County Employee Protection Act, which extends whistleblower protection to the Miami-Dade County Commission on Ethics and Public Trust, so it clearly can be done to give us that authority. And then it throws a softball, and it says, if the city adopts an ordinance on whistleblower protections, we would ask you to include us as an authorized entity. Now, this is something, I'm not suggesting that we do or don't do anything, but it is something that we could do in follow-up to that whistleblower protection discussion by Mr. Reed last month.
Mr. Chair, what would be the downside?
What would be the downside to this?
I mean, I think, so you're asking if this board would support you sending that letter to the city commission?
I said at the last meeting, I think Ms. Graywall raised the issue, but I said at the last meeting I'd bring you back something if the board wanted to follow up. So I'm not making a motion here, but I'm just saying this is something we could do. I'm sure there are softer and I'm sure there are harder options. So I'm looking for guidance in terms of what the board wants it to do, if anything.
We're all looking at you now.
And here comes the bus.
Yeah, no pressure. Is there any desire on the board's behalf of taking this further as well? I mean, right now the letter has been drafted, but in terms of actually drafting anything, does anyone have any interest in that as well? I mean, I guess I will not be privy to it, so whether or not.
I'll let you know in Fort Myers. So currently, and I mean, I apologize if I don't know the answer to this question, but currently there is no, who has whistleblower protection, who can provide whistleblower protection within the city of Tallahassee?
What the statute says is the chief executive officer is someone to whom you can report and they can offer whistleblower protection. But a local government, by ordinance, can expand, can put in place whistleblower procedures and can create authorized individuals or entities who can create whistleblower protection. So since there is no ordinance, it would mean in Tallahassee it would be the city manager. That was what Mr. Reed told us last month.
Okay, that's what he told. So is there any city policy addressing whistleblowers?
We got a response from the city, I believe it was an email, Ms. Meadows-Keefe. Yes, that basically said it's the state law says this, so it's the city manager.
Okay. I believe that the Leon County School District does have a whistleblower policy. I remember, I think that they do.
I think there's case law specific on school boards on whistleblower that says because they don't really do ordinances that they can follow the statute by doing a policy.
Okay.
But for a city, it would have to be an ordinance. So what this does is it doesn't really particularly take a position on the lack of an ordinance. It just says if you ever do an ordinance, we'd like you to include us as an entity.
Has there ever been any discussion at city level about developing a whistleblower?
I don't
Board?
believe we know.
Okay.
Is there a reason not to specifically recommend such an ordinance?
Well, if you wanted to do that, I just happen
Okay, you just
To
happen
have.
have something there.
Plans ahead.
I know. I'm freezing up here, by the way. Don't want anyone else to worry about me, but it could potentially snow. There's a chance. Is it cold out there?
I have 3 coffees.
I'm coming with my parka next time.
Parting gift.
So what's different with this, Mr. Chair?
If you look at the bold language in the
Yep.
middle, that's essentially what's new. And it says, basically, we don't think the city has such an ordinance as far as we know, and we think that it ought to, and we think you ought at your earliest convenience to do one, and we think we ought to be included. So this one goes beyond include us to say, we're recommending that you have an ordinance. We think we think whistleblower is within the realm of ethics generally. We think that having an ordinance is the responsible thing to do. And in addition to that, we think we ought to be one of the authorized entities to receive whistleblower complaints and offer whistleblower protection.
So we don't know if this is ever, I'm sorry, I'm not being formal, Mr. Chair. So we don't know if there has ever been a discussion at the city level about developing, drafting the whistleblower protection ordinance? Do we know the answer to
I
that?
do not. Ms. Meadowskeefe, do you know any more on that than I do?
I don't know enough to cogently answer the question. I do know there have been discussions with the city attorney's office and maybe other entities within the city, but I've not been privy to those.
Well, I would move that we table this and get some answers to those questions. I'd just be curious, is there any background to this that the city has already acted upon or not acted upon? And then I think with that information, we can make a better informed decision as to whether to go with option A or option B.
Okay, perfect. We will
I'm
put
sorry
it.
you won't be here for that.
We'll send her an email.
You can watch the video.
We will put this on next month's agenda and do nothing or do A or B. I think
Yeah.
there's really 3 options.
Yeah.
There's, we can decide that
Yep.
this is just not.
I'm curious. I'd
us.
like to know that before we
Sure.
take action.
Absolutely.
Thank you.
Okay. Very good. That moves us to public comment on non-agenda items. I'm sorry? Oh, I'm sorry. I skipped number 10. I handed out to you, we always have this, and typically we don't get much, and it seemed to me it was an opportunity. One is if any of you have anything you want on next month's agenda, and I think we've got a couple things that you've raised during the meetings, like this whistleblower thing, Ms. Graham.
Yep.
But a couple other things have come up tonight. But it seemed to me it was also an opportunity for me to point out things that I know that are natural follow-ups. So I want to point out from my perspective things that I think ought to be on next month's agenda. We need to get those 4 forms that are mentioned in the documents we adopted tonight. I give you a copy of the ethics officer job description and performance, the last 2 performance evaluations we've used. One is relatively short and one is relatively painful, so that you can look at those, because since we typically do the evaluation in August, September, we need to get those revised. The reason we haven't looked at the job description in the past, when I read it, it seems to me that there is at least one thing in there that there are a couple things that need to be changed, because one is at least arguably inconsistent with the city charter. So we just need to get everybody comfortable with what's in the job description, that it says what it ought to say and matches current activities. We talked about investigators in our bylaws. We need to come back and begin a process to pre-qualify some investigators and talk about what the board wants to do with finding investigators, so we're ready to roll when we need them. It's not a good idea to start thinking about how to get one when you need it, when you need him or her, excuse me, not yet. We have talked in the past about looking at the city process for registering persons who lobby the city, or the failure of persons to register to lobby, and we have not closed that loop. So that's something that we're probably overdue to look at. I see people nodding in the audience. And then last month, an issue was raised by Dr. Hollifield about meetings outside the city limits. Or outside the county or outside the state. There is case law and attorney general opinions on that, and I think we have room in next month's agenda to address that issue because it relates to public meetings. That's an ethics issue, and that is clearly within our purview. So those are things that I want to see on next month's agenda to give you fair notice. So this is the point. If there are other issues you have that you want us to raise either next month or at some point in the future, speak up.
Well, I spoke earlier about the issue of cameras, and look, this is not an issue that I want to know what the law is before any further discussion, and if I'm wrong on the law, then I will happily fold.
Right. We've got that issue. Yes, ma'am.
Okay.
Absolutely. I think Mr. Reed was already doing research while he was double billing us down there.
And there's absolutely no, just from my perspective, no desire to censor or to chill, or it's to continue to focus on the credibility and integrity of this board and what we have been tasked with doing, and not allowing distractions from that. That's the rationale behind it. Not anything weighing in on the importance of the issues that might be brought before this board that are not agenda items.
I think that falls within the category of sage advice. Yes, ma'am. So we will have that on next month also. So we're going to have a bunch of hopefully relatively fast things, but they are mostly our follow-ups to what we did tonight. I think they're the last dotting the I's and crossing the T's, or finishing those items. So that was item 10. Thank you for not letting me skip that. And please remember, every month, and particularly now that our bylaws specifically say this, if there's something you want on an agenda before the meeting, call the ethics officer, and the ethics officer will put it on our agenda. I don't own this agenda, and she doesn't own this agenda. If there's something you want on next month's agenda, raise it at the meeting, and we will put it on the agenda. Now, if it's a huge item, we may not finish it that month, but we're going to do whatever the board members want to do. So if you got a burr under your saddle, share it with the rest of us, and we'll all have a hitch in our get along. I think my grandparents would have said.
No burrs.
Okay, it's time for me to stop talking. We are now on item 11, public comment on non-agenda items. I have a card from Dr. Jackson, and it looks like there are two issues. You'll note, Dr. Jackson, that the personal knowledge to file issue is out. That came out of the document. The other issue is on the ethics officer. I have a suspicion where you are going with this. Some part of this was Ms. Graham's discussion from tonight, and it has been delayed until next month. So, you're recognized.
Yeah, Irwin Jackson, 1341 Jackson Bluff. I want to share with you, I worked all day and came over here from Mariana to be here. I want to give you some feedback on how you're being perceived by the public, because I think you sit up there and you may be missing out on some of this. I did hear that, in fact, there's this issue regarding needing to have substantially personal knowledge, and I'm glad that was removed. I had about 50 people that had contacted me and say, hey, Irwin, they're coming up with another clause, another way to keep you quiet. I thought you had this under control, Irwin. Well, why in the world? It was just such a stupid idea. Do you think Scott Maddox is going to come in here and when he does something wrong, he's going to tell you he did something unethical? I don't remember Andrew Gillum coming in here saying that he was taking tickets and bribes. No, they don't. I had to tell the Ethics Commission that's what he was doing. Did I have personal knowledge? No. Okay, I had enough other information that I felt comfortable with. Now, I understood you took it out. The only reason I'm bringing it back is that's how the public sees that. They're saying, well, why would the ethics board want to limit someone who's showing up here sharing information with you? As we look around, I don't think there's anybody here new other than, that is waiting in line to come share with you information. Most people don't want to get involved. So that's kind of a negative perception because it got in the newspaper. It should have been killed before it even got in the newspaper, my humble opinion. Now, second thing, which I didn't know about, but Commissioner Graham, Board Member Graham, what you're talking about is censorship. So don't just call it censorship. We've done three other people have already recommended what you have just talking about. I came up here 10 years ago, and we had a guy by the name of John Marks. He didn't want me to talk about ADE, Honeywell, some of his business dealings, so he put in a kill switch. All right? When I come up here and speak to you, I am talking to you, but primarily I'm talking to the people on TV, because if I can get them calling you, then I'm making headway. So I understand, just like John Marks, he had a kill switch. Well, he tried to do that. I had to go to court to make sure that I could speak.
Good. Could you provide the documents about that court and the outcome of the decision? I would love to read it.
You can get that from the city attorney. They have better records than I do.
Okay. Because again, if there is legal support for what you're saying, then I'm not going to, this is not something that I'm going to violate anyone's right to speak.
Correct. Okay. Well, let me give you another example of someone who decided that what we're going to do is to
was there a court decision, or did they just
They
just
caved
gave
like
up?
they caved. They just caved because the attorney said,
I don't cave very easily.
Yeah, well, they saved a lot of city taxpayer money.
Never want to waste taxpayer money, which is one of the reasons why turning off the TVs might be a good thing.
Yeah, well, let me, and I want to make sure if it's 3 minutes or 4, that I'm getting my full time. But it is censorship. That's all I'm saying.
I don't think it is legally.
Now I guess we'll find that out. Yeah. But you're talking about, we want transparency. Okay, now you want to fight with me, trying to censor me, turn me off the TV so no one can hear this discussion. You know who else wanted to do that? Scott Maddox. Now I wonder what Scott wanted to hide. He didn't want the public to hear. And I tell you, the third person, and he happened to run for governor. And you know what he did for the last 3 or 4 months when I started talking to him about his bad behavior, which now has been shown that he did act unethically and he was taking gifts or bribes? Andrew Gillum. Andrew, when he was mayor, told the TV folks that when Jackson comes up here to speak, cut him from the damn TV. So if you look when I'm speaking and you go home and look at it on TV, you won't see Jackson speaking.
Dr. Jackson,
that's a serious problem.
First, I want to say I like you, and this is nothing personal.
Absolutely.
My commitment to this board is to maintain the integrity and the focus on the issues that we have been asked to address as the Tallahassee Independent Ethics Board. Believe this or not, it has zero to do with you.
I agree with that because I've not done anything unethically.
No, but it has zero.
If you try to silence me,
I'm not trying to silence you. Nor
if you don't put me on TV, we have a discussion right here. I think this discussion is very helpful for the folks at home watching their TV. It'd be a lot more interesting than most of the other stuff they had to listen to.
Are you kidding? They love the bylaw part.
Pardon?
They love the bylaw part.
Well,
they were riveted to the television screen.
But what they're concerned about is you're taking away the...
We'll do this, because I certainly don't want to ever do anything that would be unethical. It would be unethical for me to sit up here if I wish to do that.
Right.
So let's let the next meeting, and I'm sure you'll be here, we're going to get a legal report on what the law says, and then we'll go from there.
But
okay?
I don't even think you need...
How'd you hurt your foot?
Well, we'll talk about
okay,
that.
Good.
Can I interject
that's not
one
nearly
thing?
as painful as the censorship that we're talking
There is
here.
no censorship
Yes,
involved.
I think there is. But anyway.
Dr.
Can I
Jackson,
interject one thing?
We will take I want to say this. First of all, there's no censorship. I understand
turn off the TV,
I
that's
completely
censorship.
understand. Again, my point is, you're making my point. You're making my point for me, and I thank you for that. But let's find out what the law is. And I will ask the city manager to give me whatever documents they have about previous issues, okay? I always want to be fair. And this is not my decision. It's going to be a board decision, and maybe we won't do anything with it. So
I'm amazed that you think by turning off the TV so the public can't hear an opposing view of yours is not censorship.
You don't have it.
Andrew Gillum did that, Scott Maddox did that, and John Marks did that. So
Sir, I'm not
you're
talking
fitting
about-
right in with that crowd, which I think is unfortunate for you.
Sir, you know that's not true.
No, you are.
know
If
that's
you
not
agree
true. You know
with
that's
turning
not
this off from
true.
TV,
And you know what? You know that's not true. And again, this is not a hill I'm going to die on.
You brought up the topic. I
is
didn't.
all
You
we-
brought up
No, you
censorship.
came up in front of this board
No,
and you brought up a
came up here.
non-agenda item to talk about this. So
You
let's
came up
move
when I was
on.
sitting over there. That's
Dr.
fine.
Jackson, let's move on.
That'd be fine.
Thank you.
Dr.
you.
Jackson, I'm going to take a minute and interject here. What I heard the board discussing was if someone wants to stand up and talk about something that has nothing to do with this board and has nothing to do with ethics, if somebody wants to come in here and talk to us about the public transportation system in the city of Tampa, and they insist on talking to us, that we could go ahead, that we would look at the legality of us going ahead and closing the meeting and then the members sitting here after the meeting in a workshop session and listening to the person talk to us about something having nothing whatsoever to do with the jurisdiction of this board or having anything to do with ethics. Now, you are mischaracterizing it when you say that we would turn the camera off on somebody in the middle of a meeting when they're talking about ethics. We would not and will not do that, and we're not going to look at the legality of that, whether it is or isn't legal, because we're not doing that.
That makes me feel
So to
much
make
better.
sure that we are properly characterizing the issue, we are talking only about issues having nothing to do with its jurisdiction of this board, having nothing to do with ethics.
That shouldn't
You're
be a problem. Anything that I've ever
Yes,
talked
thank
about.
you, Dr. Jackson. We've accomplished a lot. Thank you.
Pardon?
No, thank you. I appreciate that because that's what the...
No,
that-
I think this helps to clarify it
That's
because
exactly-
the problem that we have had
I
in the
understand.
past, you know what the problem is if the folks up there don't like a different opinion, then they cut you off
I
the
appreciate
TV.
different opinion. I revel in differences of opinion.
Well,
I
then
think
let's
we need
support
that.
the difference of opinion.
We will.
Thank you. I appreciate that.
I
And
will
then,
follow what the chair said, which is exactly what I've said, and he said it in a better way, so I appreciate that. Thank you.
Very good. The last thing that's given us a little negative view from the
Yes, sir.
public is to sit here and you hear Ms. Keefe talk about ethics and how she's a trainer of ethics, but her own personal behavior has shown that, in fact, I think she comes up a little short when it comes with ethics when she decides to enter into a relationship with a city employee. I think if we look not only with females, but if we have a male commissioner and we have a male ethics commissioner who decides he wants to have an affair with a city employee, I don't have to get a legal opinion. I think it looks bad, and I think some kind of action needs to be taken. When you're in a position, as each of you are, you have to be, in order to get the support of the citizens, you can't be talking about turning off TV. You can't be looking the other way when action needs to be taken. And I appreciate it. Thank you very much.
Thank you, Dr. Jackson. Anybody else? Need a moment. We're going to continue to follow the policy that we'll listen to anybody, and we're not going to, and unless you are being repetitive or it's an issue the board's already closed, we're not putting time limits on anybody. And even that 3-minute time limit that we just adopted is at the discretion of the chair. And you know my attitude about cutting people off, which is I don't see the point. But that's my personal attitude, and you'll get a change about next December or January, I'm sure. So anybody else with anything for Ms. Graham?
Just as follow-up, Mr. Reed, could you ask the city manager to provide any documentation about this issue previously discussed, if there is minutes of the city commission or court case that was filed or anything, just so...
Ms. Graham, we will get it
Okay.
through.
All right, Dr. Jackson, thank you so much.
And we might even find something in the press, I suspect, going back. But we'll try to give you
Yeah,
a
I just
comprehensive
like
report.
to read about it. I mean, again, this has nothing to do with anything other than my commitment to this board's integrity.
Well, and I think, again, we have, I want to reinforce what you've said. We have heard in the past some things that relate to important public policy issues, but they're nothing this board can act on, and they're nothing related to ethics.
Right.
And even in the most far-reaching sense, they may not even be anything related to morality. But they do relate to good public policy. So I think for the board to decide to sit here in a workshop session, for us as individuals, citizens of the city, to sit here and say, persuade me, maybe I'll go join the cause. I'm willing to do that, but I agree with you that we should not be spending the public's dollar on things that just aren't this board. I mean, we do have a charge.
And it is, in fact, the public dollar, and we found out tonight that the longer these meetings are delayed, and as we sit here at 6:46, the more it costs the public to broadcast them.
Yes, ma'am.
So we're actually being considerate to the public dime and not having the TV cameras roll when there's an issue that we do not have any authority to address.
Right. And I think Dr. Jackson will admit that I might have interrupted him a time or two. I don't think I have ever cut him off or asked him to limit his comments. So, and I don't expect that I probably will, because you got that weapon on your foot there. Okay. Seeing nothing else business-related, I will note that our next meeting is on Tuesday, July 16th from 4 to 7 in this location, and we are adjourned.